Hearing in the spirit of Nasir against Zavarco PLC.
May it please the Court, I appear for the appellant, Mr. Nasir, my junior Mr. Tom Hall, sitting to my left. The respondent, Zavarco PLC, is represented by Mr. Patrick Lawrence, King's Counsel, and Mr. Charles Phipps. My lords, my lady, we read in Zamir and Wolfe that the declaratory judgment is as old as judicial history. It can be traced back to the pre-classical period of Roman law. Of comparable antiquity is a simple rule of English law. No person shall be vexed twice by the same cause of action. Nemo pro causa una eidem debet bis vexari. It is a rule against double vexation. The language regarding the merger of the cause of action, the drowning of the cause of action, the extinction of the cause of action by the judgment are simply metaphorical statements of the effect of the double vexation rule. They are not to be equated with the rule itself. The Court of Appeal in this case found that there was an exception to the double vexation rule, that the defendant can be sued a second time on the same cause of action, provided the first action ended only in a declaratory judgment. We say that they were wrong to do so and have overturned a fundamental principle of English law that is, like the declaratory judgment, as old as the hills. Now, the structure of my submissions will be as follows. Firstly, I want to go through the case law on the double vexation rule. Then I want to look at the case law on Henderson and Henderson abuse, and then to address what we say are the 3 points in the appeal. The first is the existential point, should the doctrine of merger exist at all. Secondly is the scope point, if it deserves to exist, should the doctrine apply to declaratory relief. And thirdly, the application point, briefly, does the doctrine of merger apply in this case?
Is anybody saying it shouldn't exist at all?
Well, the Court of Appeal said they didn't abolish it, or wasn't going to abolish it, but it would be open.
Well, it wouldn't be open to the court. Nobody, respondent aren't asking us to overrule the Indian grace.
No, it won't.
Maybe it's point. Your second point in the third heading. You can take the first point. Should it exist at all? You can probably take briefly, because no one is asking us to say that the rule doesn't exist.
No, I was going to look at this idea that Henderson and Henderson is an adequate proxy for the rule, a good substitute for the rule.
Yes. Okay.
Now, can we turn into the case law? I want to distinguish between two types of cases. Type 1 case, where in an action a party relies on the fact that the other party has previously failed on a similar claim, and having lost on that issue, they cannot contradict the outcome of the previous decision, what we would call cause of action estoppel or issue estoppel. So type 1 are the contradiction cases. Type 2 cases are where the defendant says that they've already been sued in relation to the same matter, and having been sued once cannot be sued again. And they're what we would call the merger cases, and there the rule operates against repetition. So type 1 is contradiction, and type 2 is repetition. And the cases in relation to this doctrine, I'm going to split into 3 subheadings. Firstly, the early cases, pre-19th century. Secondly, the 19th century and some of the 20th century cases. And then thirdly, the modern cases. And I want to start, if I may, with Higgins's case. It's the first type 2 case in the bundle, and it's at tab 51, hard copy bundle 2.
We don't have bundles or tabs, so if you just give us the electronic page number, but you may have to give Mr. Lawrence the tab and volume number because he's working with paper as well. But if you could give us the electronic page number, because until we have that, we cannot find the document.
Page 656.
Thank you.
Now, what has happened here is a Mr. Themmelthorpe had deposited some money with a Mr. Higgins, who it seemed was operating as a banker. And Mr. Themmelthorpe died, and his wife, or widow, was executrix of the will, and she sued Higgins for the money deposited. And the defence was...
What's the date of this case?
The date is 1605.
1605 is the third year of...
of James the
First.
James
Yes.
First.
So we're into 1605.
The defence was that while Mr. Themmelthorpe was still alive, he'd already covered the money and 60 shillings damages. And the argument that was run in answer to that was that true it was that there'd been this action, but there'd been no recovery. So the argument was you couldn't be barred until you'd recovered your debt. The judgment, it can be slightly difficult to decode, but if one goes to page 657 and approximately 12 lines down, in the middle of the page, in the middle of the line, there's a sentence that starts, "but it was resolved." That I take it to be the start of the judgment. It was resolved.
This is Cook's own note of the case, presumably. Is it?
I'm so sorry?
This is Cook's own report of the case on which he sat.
Yes.
As Chief Justice of the King's Bench, was he? Or?
Common Pleas.
Common Pleas, then.
Yes. Yes. And the judgment says that it was resolved that as long as the judgment remains in force, he cannot have a new action on the same bond. For he who has a debt by simple contract takes a bond for the same debt or any part of the contract is determined. So when a man has a debt on a bond, and by ordinary course of law's judgment thereon, the contract by specialty, which is of an inferior nature, is by judgment of law changed into the matter of record, which is of a higher nature. If he who recovers may have a new action and a new judgment, he may have infinite actions and infinite judgments to the perpetual vexation and charge of the defendant ad infinitum injure reprobate, there's an infinity is rejected by the law. And then, following on from that, on every judgment, the defendant shall be immersed, fined, that is to say, if he be Duke, Marquess, Earl, Viscount or Baron, he shall be immersed 100 shillings, so the defendant might be infinitely immersed on one and the same obligation, which would be mischievous, again, the public interest in the finality of litigation.
What does immersed mean? I'm sorry.
Fined or punished, I understand.
But fined for what? Fined for not complying with the judgment?
No, as I understand it, and only from this report, this was if you lost and had a judgment against you, you had to pay 100 shillings.
Right.
There's quite a lot in those.
£5. I would say it's the irreducible. There is an irreducible level of vexation with every case that's brought against the defendant, and this is a measure of one.
So if he paid the debt, then he would get rid of the vexation.
If you pay the debt, you'd still have had the fine. Yes, I'll come to that point. The vexation only arises if you fight the case the second time. I have that point, and I will come to that. Now, there's some useful insight here into the origins of some of the language. If we go to page 658, and if one looks at the top of the page, 3 lines down, also a bond and bond in the nature of a statute staple are two distinct liens made by assent of the parties without process of law, whereof the one hath no dependency on the other. But in an action brought on a bond, the suit is grounded on the bond as a building upon a foundation, and the plaintiff hath judgment to recover the debt due by the bond, so that by judicial proceeding and act in law, the debt due by the bond is transformed and metamorphosed into a matter of record. And judgment in a court of record is of a higher nature than a staple statute, merchant, or any recognisance acknowledged by assent of the parties without judicial proceedings. A statute staple was, I understand it, a means of proceeding in the staple towns for a formal recognition of debt, but it wasn't a judgment. As to the objection which was made that perhaps the recovery is erroneous, to that it was answered that that was the plaintiff's fault. And although it be erroneous, yet so long as it remains in force, it ought to be executed. And when it's reversed, then the obligee is restored to his new action. And it's true that in old books, after judgment given an action on debt on a bond, the bond shall be damned, that's to say cancelled, because the duty was changed into another nature. And that was the true reason of the old books. And then there are a series of cases referred to. I can tell the court that they date from 1371 is the earliest through to 1469, so appealing back into the 15th and 14th century. And then there's a reference to a case Devon and Scott. And the court had consideration of the book in 17E3. Devon and Scott is 1343, where Edward Devon brought an action of debt on a bond of £20 against Richard Scott, who pleaded that before the mayor and bailiffs of Newcastle upon Tyne, the plaintiff by plaint on the same bond recovered and had execution. And there, because the defendant didn't procure the bond to be damned, it wasn't cancelled, the plaintiff had judgment to recover again, notwithstanding the former judgment and execution.
You can see why that wouldn't be allowed.
Well, medieval justice. And their shard, I take that to be the judge, said to the defendant, now see the deed be damned. In other words, if you don't, you'll get sued a third time. And then we have an explanation, but the court said that the judgment was given because it was the defendant's folly that the deed was not damned on the former judgment. For in the time of, now these are 1328, 1329, 1399, so it's 14th century, it was held that when a man did recover on the bond, as has been said, should be damned. Wherein the content and quietness of men in old times ought to be observed that when judgment was given against them by the course of law, they were satisfied therewith, without prying with eagle's eyes into matters of form or the manner of proceeding or of the trial or insufficiency of the pleading, etc., to the intent to find error to force the party to a new suit and himself to a new charge and vexation. But since men became more contentious and not satisfied with any trial or judgment, but writs of error and attaints, which in old times were rare, and especially writs of error, were so frequent, as of more late time they were, that judges thought over the page it dangerous to cancel the deed, either where the plaintiff recovered or where he was barred by judgment, for in both cases the judgment might be reversed by error or attaint. And therefore the reason or cause of the said judgment in, that's Devon and Scott, is now changed, and there is not any question but judgment and execution upon the bond is a good bar to a new action thereupon. Therefore the said book, Devon and Scott, is not to be urged against his judgment. So, as I understand, what that's saying is that there was a period of time when judges held back from cancelling the bond, effectively preserving the evidence, in case the judgment that was obtained by the claimant in Claim 1 was in some way attacked, vitiated by a subsequent action. There you had the bond, so the claimant could come again. But that gave rise to, obviously, the odd result in Devon and Scott, that because the defendant had not seen to it that the bond was cancelled, he was sued second time. And in Higgins's case, the court ruled that the action was barred. Now, the next case is at page 486. It's a similar time, 1604. It's bundle 2, tab 38 for those in the hard copy, and there are actually two reports of this case, one at page 485 and one at page 486. They seem to be the same case. One is reported as Brown and Wootton, the other as Broom and Wootton. Now, this was the joint tortfeasor situation. So what had happened here was that the plaintiff, it looks like he'd had a plate stolen or taken, and there were two individuals involved in that conversion. There was somebody identified in the reports as JS, and there was the defendant, Wootton. And the plaintiff in the first action had sued JS and had obtained judgment for £20, but didn't get paid. So they sued the other tortfeasor, the joint tortfeasor, who'd been engaged in the taking of the plate. And the defendant in Wootton, in this case, pleaded that the former action excluded the right to come again. So if you sued one joint tortfeasor, you couldn't sue the co-tortfeasor in the second action. Of course, a rule that's now been abolished by statute. And if we look over the page, at page 487, we see that 4 lines down there's this argument advanced for the plaintiff in answer to the plea. Clark for the plaintiff argued that it was not any plea because the having judgment and the parties being in execution is not any satisfaction unless the money was paid, and therefore by pleading without satisfaction it's not any plea in the bar of the action. It was effectively a demurrer. And then skipping down to the next paragraph, but all the court held the plea to be good, for the cause of action being against divers, for which damages uncertain are recoverable, and the plaintiff having judgment against one person for damages, that which was uncertain before is reduced in rem judicatum and to certainty, which takes away the action against the others. And there the defendant succeeded. Now that was a type 2 case. Higgins's case was a type 2 case. The next case is actually a type 1 case, and that's Putt and Rawston. Just bear with me. And that's page 914.
It's the most unjust result, that last case. Somebody's not being vexed twice at all. They're just being vexed because the other person against whom a judgment was obtained has failed to pay.
Indeed, but reversed now by the 1934 Act.
I know, so not really relevant, I would have thought, to this case.
Not relevant. Well,
what's the relevance of it as far as
well, it's this. The principle is so well entrenched and has only been disturbed by Parliament. The principle, the rule against double vexation is so well entrenched and is only disturbed by statute. Putt and Royston, again, there are two reports, we believe, of the same case, reported at page 910 as well as Putt and Rawston. The report at page 910 contains mainly the argument. The report at page 914 contains the judgment. And if we just take it from the judgment at page 915, halfway down, Lord Chief Justice, I take Ferrer's case to be good law and not at all to be shaken. I reckon the difference, I should say the facts of these, I'm so sorry, was that the plaintiffs had sued the defendants in trover damages for converting goods to their own use. They were 9 feather beds and some other goods, and they claimed £1,000. But the plaintiffs had already sued in trespass and the defendants had pleaded not liable or not guilty in trespass and had succeeded. So what the argument here was, well, if you lost in a claim for trespass, it must mean you should lose in a claim for trover, effectively conversion. So this was a contradiction case, a Type 1 case. But we do get some insight into the approach of the court if we look at the judgment of the Lord Chief Justice. 4 lines down after the reference to Ferrer's case, you say that trespass will lie wherever trover will. It's a manifest mistake, for trespass lies not on bare denial, as trover will on a demand and denial. In an action on the case, in an action of detinue, the same evidence will maintain both actions, so that it's not the action in its own nature, but the evidence that does specificate them. When a man mistakes his action, it's unreasonable to oust him of any other. In Ferrer's case, the evidence was discovered, but here it's generally not guilty. Where the verdict is for the plaintiff, where the property is altered because of the recompense given in damages, and you know an accord with satisfaction is a good bar, which is not so high as a judgment, so that the chief business is the satisfaction. But this verdict for the defendant does not alter the property. So I think it no bar. We must intend it as a mistake of the action. So 2 things from that. Firstly, obviously, these were in the days in which the rules about forms of action were very strictly applied. And one sees from time to time mention in the case law of the difficulties that arise if the claimants use the wrong action by mistake. And what the court here is saying, they're inferring that the claim in trespass, the finding against the claimant, wasn't a finding on the merits. It was a technical failure in the form of action. And so, therefore, because it wasn't, we would say, the same cause of action now, that's how the language has flowed through, but there, that wasn't the same form of action, it was permissible. The result was there was no bar there. This is, I believe, it's the first time that there is a distinction between a Type 1 situation and a Type 2 situation, where the Lord Chief Justice seeks to draw a distinction between the case where you succeed in the action, giving rise to a higher right, and a case where you're merely seeking to contradict the outcome of the previous case. In the latter situation, you're entitled to look at what actually happened in the former case. Now, those are the very early cases. We move now to the 19th to 20th century cases, and these we need to look at because there is a series of cases here that the respondent relies upon as support for its argument that the doctrine of merger does not apply to declaratory judgments. In other words, they take some quotations from some of these cases and they say it's what the judges are talking there is about coercive judgments. So I want to just look at those, and they are cited in Spencer Bower. Now, the first one is Outram and Morwood. If I can just give the court a sign of where we're going, there are 4 cases in this category. Outram and Morwood, 1803, Smith and Nichols, 1839, King and Hoare, 1844, and Kendall and Hamilton, 1879. So the first one is Outram and Morwood, and that's at page 874, and that's tab 60, hard copy. Now, this was a Type 1 case. What had happened was there'd been a claim in trespass. The defendant had broken into the plaintiff's field, Great Cow Pasture, and had dug up some coal and taken it away. And the defendant, in answer to that, if one looks at page 875, one doesn't need to look at the detail, but if one looks at page 875, third line down, there's a sentence that commences, John Zouch on the first day, 15th Jack 1, that's I think 1595. And what effectively is being said here is that the defendant had a right to go into the field and take the coal away. And they've traced that right back through 200 years of successive title. Now, what the plaintiff then said is, well, this isn't fair because this is not the first time this has happened. Previously, the wife had broken into the field and dug up some coal, and I sued the wife for trespass, and the wife's answer was exactly the same as is being given in this case, the John's Ouch title argument, and she lost. And so it's not open to the wife or her privy to argue the same defence. So this was a Type 1 case, as I say, it was a contradiction case. And the outcome was that the previous action created an estoppel against the wife and her privy, so therefore the defence was barred. Not a surprising result, perhaps. But if we look at some of the reasoning of the Chief Justice Ellenborough, page 877, halfway down, there's a sentence that commences, just over halfway down, it was moved that the bar was not good. It was moved that the bar was not good because the defendant had not averred his title, and the recovery in one action of trespass is no bar to another. Now, the argument that therefore is being run is that you can envisage cases where you might have one action in trespass which doesn't succeed, and another action in trespass which does succeed. And so therefore it's possible to contemplate contradictory recovery outcomes, even though both outcomes are right. One's not actually contradicting the result. And the quotation, the relevant quotation relied upon by the respondent, if one picks it up at...
but was it different coal? Was it...
Same coal, same field.
So it was the same coal that the wife had taken?
Well, not literally the same.
No, well, that's what I'm asking,
pasture.
whether it's literally the same.
Yes,
so
it was the same.
The wife dug up some coal, she was sued, she lost.
Yes.
Then later the husband dug up some more different coal in the same field and he was sued. And the question was whether he could raise the same defence as the wife had failed in her defence against the coal that she had taken.
Exactly.
Right.
Exactly.
So it's not bringing a second action in relation to the first lot of coal. It's a new trespass.
It's a Type 1 case, so it's not a merger case. Yeah. It's not a repetition case. It's a contradiction case. But if we look at about three-quarters of the way down...
Which page? Sorry.
So it's page 877.
Yeah.
Just above the number in square brackets 355 from the old reports. The court very properly distinguished there between what operates by way of a bar to a future recovery for the same thing and what by way of a estoppel. That was a case of mere recovery, it's the earlier case. Sorry, that was the earlier case in this, the case against the wife.
Referring back to, yeah.
Indeed. That was the case of mere recovery in ejection firme without title alleged, and the plaintiff might, in some respect of possession or other varying circumstances of title, be well entitled to recover at one time and not the other. Now, that is not quoted by the respondents in their statement of case. What is quoted is what follows. It's not the recovery, but the matter alleged by the party and upon which the recovery proceeds, which creates the estoppel. The recovery of itself in an action of trespass is only a bar to the future recovery of damages for the same injury, but the estoppel precludes parties and privies from contending to the contrary at that point, or matter of fact, without having been once distinctly put in issue by them, or by those to whom they're privy in estate or law, which is on such issue joined. So what the court is not there distinguishing between coercive judgments and declaratory judgments. What the court is saying is, true it is, you can imagine a recovery in one instance and not in another, and there'll be no offending any of these principles. it's not the recovery that's the point here. It's not that the claimant failed to recover in the previous action. It's the issue that was at stake. In other words, one looks at the specific reason why the recovery failed. So one cannot, we say, elevate this to some form of authority on the application of the doctrine of merger to declarations. The next case is Smith and Nichols. That's at page 952, tab 69. What happened here was that the defendant was a public officer and governor of the island of Fernando Po, which is now Bioko. It's just off the west coast of Africa, about 40 miles from Cameroon. And the defendant had been, looks like the master of a vessel, the Admiral Owen. I think it was his vessel, in fact. And it had been arrested by the governor. I'm so sorry, the claimant, I should say, was the owner of the Admiral Owen. The defendant, the governor of Fernando Po, had arrested the vessel for breach of navigation laws. And they'd taken the vessel and its cargo to Sierra Leone, to the north, which was a British colony, for a determination of the point. Now, the plaintiff, that is to say the owner of the vessel, was acquitted of the breaches of the navigation laws, and the vessel was returned. And the owner of the vessel, the plaintiff, sued the defendant, governor of Fernando Po, in the courts of Sierra Leone and won. They sued for the damages that had been caused by the false arrest of the vessel and the like. And it seems that what happened then was that the plaintiff sought to recover on that judgment, the Sierra Leone judgment, and failed because the governor said, well, I wasn't present in Sierra Leone when this judgment was given. I didn't appear at the trial. I didn't even know it was going on. It's all a nullity. I have no responsibility. And it seems that those arguments succeeded. So the claimant's attempt to enforce the Sierra Leone judgment were frustrated. So what the claimant then did is brought an action in this country. And what the defendant said there was, you can't sue here. You've already sued me in Sierra Leone, and so therefore that action bars this action. So I think it's a slightly unattractive position to adopt. Now, if one looks at the quotation that is relied upon by my learned friends, there are two quotations. If one goes to page 957, just under halfway down the page, there's a paragraph which commences, "It's admitted that no case." And then 3 lines below that is the quotation. "The ground on which a plea of judgment recovered bars the plaintiff from any further action is that the original nature of the debt or damage, where it may be sought to be recovered, is changed, that he has a higher remedy. He has a judgment in a court of record on which he can issue an immediate execution. And inasmuch as an immediate execution could be issued on his judgment, it would be a very superfluous matter and give great encouragement to litigation if he were allowed to commence de novo and bring another action on that, which was the original ground of complaint." And what my learned friends do is they focus on the words, "He has a judgment on which he can issue an immediate execution." But that is not a consideration of the difference between a coercive judgment and a declaratory judgment. That's simply a reference to the defendant's unattractive argument in this case, which was, you sued me in Sierra Leone, you can't sue me again here. And what the court is saying is that judgment was really worthless to the claimant. And then the other quotation further down.
Maybe so, but the principle seems a sound one, doesn't it?
Well, we say not so. We say that there is a fundamental principle: no person may be sued twice on the same cause of action. It's never been doubted until the Court of Appeal in this case, never been suggested that any exception to it. We say that's fundamental.
Well, I mean, you can't say that. I mean, there's been a textbook that has repeatedly said that this doctrine doesn't apply to declaratory judgments.
The first edition, Spencer Bell, did not mention declaratory judgments because declaratory judgments weren't really a thing then, or having any prominence. The fourth edition mentions declaratory judgments. We're looking now at the cases that are relied upon for that proposition.
No, there may be nothing in these cases, but I think your submission went further than that.
I said no case.
One thing that would help the court, I think, you have said at the outset that both declaratory judgments and the rule against a double vexation are ancient. When did declaratory judgments become an active part of English litigation?
Well, Zamir and Wolf say they begin to come to the fore in 1850, from 1850 and more in the 20th century.
Yes, so while the Romans may have been familiar with the concept, it appears that England wasn't for a long time.
Well, they say it's as old as judicial history, quoting Bouchard, as old as judicial history. But it's fair to say that in the mid-19th century, people didn't have the possibility of a declaratory judgment in the forefront of their mind, no doubt.
Thank you.
So what was the outcome in this Smith and Nicol then? That
Not barred because the ratio of the case is that if one looks at page 958, Justice Bossanquet, the ratio of the case, 3 lines down, the foreign court is not a court of record. So the ratio of the case is not that you can be sued on the same cause of action twice.
was there any discussion about whether the governor could have defended the claim in England on the basis that the vessel had been guilty of the breach of navigation laws?
I don't believe so. But there was reference to, if one looks at the bottom of Mr. Justice Bossanquet's judgment, it appears to, by replication in this case, the defendant was out of the jurisdiction of the court at the time the judgment was given against him, and there is nothing on the record which shows any law that the colony such a judgment is binding. In other words, because he wasn't there, the judgment isn't binding. In this case, there is at least a symmetry to the position, as my lady points out, because in the second action in London, the governor can defend the case on the merits. He can say, well, that there was a breach of the navigation laws.
So the Sierra Leone judgment is neither a bar to the claimant bringing the fresh action, nor does it preclude the defendant raising the same defence that had been unsuccessful in the Sierra Leone.
That's correct. So, of course, the rule against double vexation is both for the claimant and the defendant. So it's to stop any party being vexed by the same matters twice.
So in the present case, is it common ground that if this claim for the 36 million euros is going ahead, it will not be open for the defendant to say, I already paid because there was an agreement between us that instead of cash, you would get the shares in the subsidiary?
I think it would be common ground we couldn't run the exact same defences, but the more interesting question is, could we run another defence that hadn't occurred to us first time around, that's not been ruled upon? I'm sure what the claimant will say is, no, you can't, because we shouldn't be vexed by the same issue twice. You've lost the first claim, and even an afterthought, a defence, can't be run. So that's what I mean about the asymmetry. There is an asymmetry in our case, because whilst the rule against double vexation, if we can't rely upon it, but the claimant can, to mean they don't have to be troubled by other defences. At least in this case, Smith and Nichols, there was no asymmetry. The position was equivalent. both sides are on a level playing field come the second action. But we say you simply cannot read into this passage authority for the proposition that the rule against double vexation only applies to enforceable judgments. It was a reference to the facts of this specific case. The next case in this clutch is King and Hoare, which is at page 775, tab 55. Now, this was a Brown and Wootton situation, but this time in relation to a debt. So what had happened here was that there was a purchase of goods by Mr. I think these are men, Mr. Hoare and Mr. Smith, and they hadn't paid for them. And the claimant sued firstly Smith and got judgment for £16,000 plus £90 damages and costs. But Smith didn't pay, so the claimant went after Hoare. And the question was, is the second claim barred by the first? Now, this again is a rule about joint liability that's been abrogated by a statute, the Contribution Act, 1978. But this is relied upon by the respondents as authority for the proposition that the doctrine of merger only applies to coercive judgments. And there are, again, two quotations. Firstly, at page 779, and it's the paragraph which commences, if there be a breach of contract, at the top, if there be a breach of contract or wrong done, or any other cause of action by one against another, and judgment be recovered in a court of record, the judgment is a bar to the original cause of action, because it's thereby reduced to a certainty, and the object of the suit attained so far as it can be at that stage, and it will be useless and vexatious to subject the defendant to another suit for the purposes of obtaining the same result. Hence the legal maxim, transitum rem judicandum. The cause of action is changed into a matter of record, which is of a higher nature, and the inferior remedy is merged in the higher. This appears to be equally true where there is but one cause of action, whether it be against a single person or many. And so the rule here is applied simply because it's regarded as a joint responsibility. It's indivisible in that sense. The judgment of a court of record changes the nature of that cause of action and prevents its being the subject of another suit. And the cause of action being single cannot afterwards be divided into two. And then there's reference to Brown and Wootton, which was the equivalent situation, but in the tortfeasor context. And then the other quotations over the page at page 780, there's a paragraph that commenced during the argument, and it's 4 lines above that, 5 lines above that. These considerations lead us quite satisfactorily to our own minds to the conclusion that where judgment has been obtained for a debt, as well as a tort, the right given by the record merges, the inferior remedy by action for the same debt or tort against another party. Again, we say that the court here is simply not focusing on the difference between coercive and non-coercive judgments.
It may not be focusing on it, but it states a principle which doesn't, you can't read across to declaratory judgments. But
the principle we say that's operative is the principle is no person can be sued twice on the same cause of action.
Yeah, but then you have to consider what a cause of action means, and if it means a right to an order from the court, that seems to sound principle.
Well, that's a different point. It's a different point to say, I accept that you can't be sued twice for the same cause of action, but here this isn't the same cause of action because it's a different type of remedy, and I can come to that. But the principle is sacrosanct. What happened in this case...
But a declaration isn't a remedy at all in the relevant sense. It simply declares a specific rule of law. that some individual has a particular right.
Well, the remedy is a type of it is a remedy.
Well, all right, if you want to use remedy in a very broad sense, it is, but it's not an order from the court to anybody to do anything.
Can I just, because I will come to this, but can I just make this point, though? There is a difference between saying you cannot be sued on the same cause of action twice, but in this case, it wasn't the same cause of action, for whatever reason, and you can be sued on the same cause of action twice, provided the former action ended only in a declaration. Those are two different routes to getting to where the Court of Appeal got to, and it's very important, we suggest, to identify which route one's going to.
Well, whether they're different or not will depend very much on how you define cause of action, which you'll probably be coming to.
I will come to that.
Just going back to 779, that passage that you read out, if there be a breach of contract, why does it say, because it's thereby reduced to a certainty and the object of the suit attained so far as it can be at that stage, and it would be useless and vexatious to subject the defendant to another suit for the purpose of obtaining the same result? I mean, what does it mean, so far as it can be at that stage, and does that have any relevance to the present?
I'm not sure I have an answer to that specific question, that specific language, but it may help if I point out that the logic that seems to have been followed in King and Hort is step one, there is a rule against double vexation. Step two, the effect of that rule is that a cause of action merges into the judgment and no longer exists. Step three, in a situation where you have two jointly responsible parties for a cause of action, you can't divide the cause of action up. Now, it might be said, as I think my Lord Legate points out, well, you could say, well, the second claim doesn't vex the same defendant twice, and that's a fair point. But the reason that one gets to the result in King and Hort is through that logic. Step one, you can't have double vexation. Step two, that means that the cause of action goes with the judgment. Step three, you can't split up the cause of action, it's joint, it's indivisible. And that's how we get to the result here.
I would have thought he's saying so far as it can be at that stage, because you might think the object of the suit is to get some money off somebody, and that ultimate object's not achieved because the person in the event doesn't pay, but you've got the result, which is an order from the court requiring somebody to pay some money.
That could well be. That could well be what's happening. The last case in this clutch is Kendall and Hamilton, which is at tab 54, page 732. This was a Type 2 situation. Mr. Kendall had lent substantial sums to Messrs. Wilson and Maclay for speculative purposes, and they hadn't paid them back, and he sued and recovered judgment but didn't get paid for the judgment. And then afterwards he found that Wilson and Maclay had a silent partner, Mr. Hamilton, so he went after Mr. Hamilton. Now, this was a decision of the House of Lords. It was a 7-judge panel. The Lord Chancellor Earl Cairns, Lord Hatherley, Lord Penzance, Lord O'Hagan, Lord Selborne, Lord Blackburn and Lord Gordon. Lord Penzance dissented. One of the arguments that dominates the judgments was that this doctrine of merger is a creature of the common law, and after the Judicature Acts it doesn't survive, because where equity conflicts with the common law, equity prevails. And it was, I think it's fair to say, there was a fair representation of Chancery background on the panel. Earl Cairns was a Chancery lawyer and the like. Now, can I just explain the result? 3 of the court thought that this wasn't really a case about merger at all. It was a case about the liability of an undisclosed principal. I'll show you court that in a moment. Those were Earl Cairns, Lord Hatherley and Lord O'Hagan. Lords Selborne and Blackburn appear to decide the case on the basis of merger. Lord Gordon said he agreed with the Court of Appeal, but it's only a very, very short judgment, and it's not clear which argument he was supporting. And Lord Penzance dissented. If I can just very quickly show the Court the relevant references. So I won't read it, but if one looks at page 741, about a third of the way down, paragraph commencing, I will presently endeavour to express to your lordships, 3 lines down, but I must first suggest to your lordships that the facts of the case, when properly considered, would seem to me to make it doubtful whether the questions which I mentioned really arise in this case, and whether the case doesn't fall to be determined upon considerations somewhat different. And then he goes on to deal with, if one looks at 742, for example, the position of an agent for an undisclosed principal. The passage relied upon by the respondents is from Lord Penzance in the dissenting judgment, and that's at page 754. Top of the page, the doctrine of law regarding merger is perfectly intelligible where a security of one kind or nature has been superseded by a security of a higher kind or nature. It's reasonable to insist that the party seeking redress should rest upon the latter and not fall back to the former. In like manner, when that was originally only a right of action has been advanced into a judgment of a court of record, the judgment is a bar to an action brought on the original cause of action. The reason for this result are given by Baron Park in King and Hall. The judgment is a bar to the original cause of action because it's thereby reduced to a certainty in the object of the suit attained so far as it can be at that stage. It will be useless and vexatious to subject the defendant to another suit for the purpose of attaining the same result. Hence the legal maxim, transit in rem judicatum, the cause of action is changed in the matter of record, which is of higher nature, and the inferior remedy is merged in the higher. The respondents focus on the word security, and they say there you are, that's reference to coercive decisions and not declaratory relief. And we say that's not simply what the court is considering there. And in one sense, a declaration is a security because it gives the party who obtains it comfort in relation to their legal rights, as indeed happened in this case. It gave the claimant security that the shares could be forfeited.
The thing is, after you've got a judgment, a declaratory judgment, another action is not being brought for the purpose of obtaining the same result.
No, but neither would it be if you, for example, obtained an injunction on an exclusive supply agreement and then came back the second time for damages. Well, or neither would it be in the Indian Grace, where you sue for one damage to cargo and then you sue for, or short delivery, and then you sue for damage to a different part of the cargo.
That depends how broadly you conceive result, but in each case you could have got a judgment. You could have asked for damages as well as for an injunction. It's another form of order. But a declaratory judgment isn't seeking any form of order at all. It's just seeking to establish what the legal rights of the parties are. Well,
one's got to, as I say, I will come to this, but one's got to then say, well, what is the rule? If the rule isn't this very simple, universal rule about being sued twice on the same cause of action, is it being sued with the same remedy? It can't be, because cases like the Indian Grace, Clark, Focus Asset Management, Fraser, HLMAD, all those cases would have been decided differently because those are cases where the claimant didn't obtain the relief that they were entitled to on the basis of the first judgment, but didn't actually obtain. Or is it that you can't perhaps recover the same type of relief? So you can't then sue for damages, one set of damages in relation to a breach of duty, and then you can't come back and say it was the same breach of duty but because it's the same type of relief, damages, it's somehow barred, and that gives rise to all sorts of anomalies. I suppose in one sense we could say that if that was the law, that was the course that was open to the court in the next case we're looking at, which is Brunsden and Humphrey. So perhaps we'll look at Brunsden and Humphrey. This is one of the slightly more controversial cases subsequently. 1884. Just bear with me. It's page 488 and tab 39. Now, this was a case where a taxi driver, a cab driver, had a collision, road traffic accident, and he sued the employer of the other driver, and he sued for damage to his cab, the property damage, and he won, and then he sued again for personal injuries. Now, the case is resolved on the principle, we say, the principle that I commend to this court, is it the same cause of action? That's the simple test. The result was that it was permissible to do this, to sue once for property damage and then again for personal injury. So if we look at page 491...
Well, couldn't that case be dealt with under Henderson against Henderson principles?
Well, this is why, of course, I have to deal with whether Henderson and Henderson is an adequate substitute. And can I deal with that when I come to the Henderson and Henderson cases?
Yes.
So, bottom of page 491, last few words on the page. The question is whether there are two causes of action or whether there is only one. And if there's but one cause of action, the present suit is not maintainable. And then, how is that test to be applied? Page 493. And this is the Master of the Rolls. About 8 or 9 lines up from the bottom of his judgment, this one test shows that the causes of action as to the damage done to the plaintiff's cab and as to the injury occasioned to the plaintiff's person are distinct. Can I just be clear? What the reasoning is that because an action in negligence is not actionable per se, the wrongful act, the negligent driving of the other vehicle, doesn't give rise to a cause of action. You need damage. And then the question is, well, what damage? And so you have damage to the cab, well, that's one cause of action. And then you have damage, personal injury damage, which is the second cause of action. So the result was that there were two causes of action. And then if we look at Lord Justice Bowen, page 494, just over halfway down the page, there's a reference to the legal maxim. The principle is frequently stated in the form of another legal proverb, nemo debet bis vexari pro aidem causa. It's a well-settled rule of law that damages resulting from one and the same cause of action must be assessed and recovered once for all. And then there's the reference to the difficulty that arises. And then over the page 495...
I mean, the principle there stated is easily understandable.
Yes.
And certainly there is an equivalent rule in Scots law. Yes, 495.
Then 495...
So they've said that he could maintain the second action for personal injury,
Yes.
even though it arose from the same collision.
Yes, and the case has been commented on with questions such as, well, could he sue once for the trousers damaged, and then secondly for the damage to the leg under the trousers, as an example of ad absurdum.
It does seem a rather unsatisfactory outcome.
But the ratio of the case, whether one agrees or disagrees with the conclusion reached, the ratio of the case is clear. if it's the same cause of action, there's an absolute bar. If you're going to not apply that bar, you have to find a way of saying it's not the same cause of action. And then
as stated at 494, it doesn't go as far as you need it to go, because it's the principle against double vexation there is in context being referred to as preventing two claims for damages from the same cause of action. Yes,
but we have to then look at this in the light of how the principle has been applied more recently, of course. But yes, I accept that. And then page 495, 12 lines up, from the bottom, according to the old distinctions of forms of action, which still have a historical value as throwing light upon the principles and definitions of the common law, the form of action upon such a hypothesis would have been trespass to the person, for the personal injury, trespass to the goods, for the damage to the vehicle. Injury would have been done to the plaintiff in respect of two absolute and independent rights, the distinction between which is inveterate both in English and Roman law. And that's the point about the damage is a constituent element of the cause of action. And then page 497, final paragraph on that page, last paragraph. This leads me to consider whether in a case of an accident caused by negligent driving in which both the goods and the person the plaintiff injured, there is one cause of action, only of two causes of action, which are separate and distinct. Difficult question to answer. And then at the bottom of the page, two separate kinds of injury were in fact inflicted and two wrongs done. Lord Coleridge dissented. So that's Brunsden and Humphrey, followed very quickly by Sereo and Knoll, which is at, just bear with me, page 940.
Is Brunsden still good law in English law?
Yes. Yes. It's
not. How can you square it with the Indian Grace, though?
It's a very good question. One squares it on the basis that the finding was there were two causes of action there, and in the Indian Grace it was found there was one. Some of these cases are difficult to reconcile, I accept that. Sereo Knoll is very difficult to reconcile with Leon Green, as we shall see. But the approach is always the same. The approach is always, is there one cause of action or two? If there's one, there is an absolute bar regardless of case-specific merits. So Sereo and Knoll, page 940, and the reason I look at this case is because Lord Justice Sales in Farrer and Leon Green, which is a case that's difficult to reconcile with this case, found the ratio of this case difficult to discern. I want to just explain what we say the ratio is. The fact of Sereo and Knoll, what happened was, and can I just also point out that the Master of the Rolls and Lord Justice Bowen are on the panel in this case. So they were on the panel in Brunsden, and they're now on the panel in this case. And what had happened here was that the plaintiff, Mr. Sereo, had delivered some share certificates in a mining company with a blank signed stock transfer form to his broker, Mr. Bird. Now, Mr. Bird was dishonest, and he took those shares and pledged them as security for a debt to a firm of stockbrokers, Foster Braithwaite and Company. Now, Mr. Bird was then found dead from poison in his bed. One wonders whether his misdeeds caught up with him. And Mr. Sereo then came to learn of the position and went to court to stop the shares being registered to Mr. Knoll, to the effectively registered on the stock, the blank stock transfer
Was
form.
that the person who had received the security for who had made the advance?
I'm not sure. I'll come back to that. It's definitely was from Foster Braithwaite and Company. Can you just check that? I had a feeling that it was actually for a sale of the shares, but I'll just check that. Now, so Mr. Serra went to court and he issued a claim form seeking delivery up of the shares, and the claim form included a claim for further or other relief. Now, on the 23rd of February 1882, there was a consent order for delivery up of the shares on that day. Those were the words of the order. But the shares were not delivered on that day. They were handed over on the 28th of April 1882, and in the meantime, they had depreciated in value. So Mr. Serrao brought a claim for those damages. And the jury found for the claimant and awarded damages of £140. But the issue there then arose was, isn't that claim barred by the first claim where you obtained delivery up? And Mr. Justice Grove considered the position, and he found for the claimant, he found that it wasn't barred. So the case then went to appeal. And as I say, Lord Justice Bowen and the Marshal of the Rolls are sitting, and of course they will remember Brunsden and the fact that the taxi driver had two claims, and this seems more meritorious, one might think. So page 946, we see Lord Justice Bowen intervening and referring to Brunsden and Humphrey, so he's clearly got it in his mind. And then, if we go to page 948, the Marshal of the Rolls decision, it's unnecessary now to determine whether there's a fresh cause of action for every day upon which goods are detained, and whether separate actions of detenue can be maintained for each day's detention. And then over the page, halfway down, even before...
This is page?
Page 948, I'm so sorry. Halfway down...
949 you're now on, right?
949, I'm so sorry. Yes. 949, halfway down, even before the Supreme Court of Judicature acts, and still more now, no more actions than one can be brought for the same cause of action. And I'm of the opinion that there is but one cause of action in the present case. And then page 950, Lord Justice Bowen, I too am of the opinion that the defendant is entitled to judgment. The principle is that where there is but one cause of action, damages must be assessed once for all. The plaintiff relies upon a certain cause of action. Was this cause of action capable of being litigated in the suit in the Chancery Division? If that had been an action of detenue at common law, the jury in their assessment could have included not only damages for the original wrongful detention, but damages for the detention until the shares should be redelivered. Damages might have been assessed once and for all. And the result there was that the action was barred. Now, just...
That's a bizarre result, because at the time he brought the first action, he didn't know that the guy wasn't going to hand him the share certificates in compliance with the order, or unless... Are you sure that that's the fact pattern, that it's not the depreciation in the value of the shares up until the date of the order for handing?
No, I don't believe so.
How could he have brought a cause of action? How could he have included in the first cause of action, first claim, damages for failing to comply with the order he got as a result of that first claim?
I think the suggestion is that you could have included general and specific claim for damages, because you don't know what's going to happen to the value of the shares after you issue the claim form until you get delivery up. So you could have
a recipe to ambush litigants. So you make a claim not knowing whether or not you will have one.
Well, Farrar and Leon Green, you'll be pleased pleased to know, very similar facts but different result. But Lord Justice Sale said that this case, that the ratio of this case is unclear, but the ratio of the case is clear. Both judges are saying if it is the same cause of action, there's a very strict rule.
Couldn't they have sued on the judgment?
I'm so sorry.
Could they have sued on the judgment? There was a failure to comply with the judgment. I mean,
It was a contempt. I mean, nowadays they would have brought out...
Well, there may, who knows, there may have been some other route. But my submission is we don't have to be troubled by that. What we have is a potentially strict, I accept, rule. There are plenty more hard cases more recently. I mentioned a few. Indian Grace is a hard case. Clark and Focus Asset Management is a hard case. Fraser and HLM is a hard case.
So what's the point of these hard cases then? What policy do they...
That you can't be sued on the same cause of action twice.
Well, you say that, that's the rule, but what's the purpose of the rule?
The purpose of the rule is public policy that's to prevent multiplicity of suits.
But if that public policy is then resulting in these cases which seem very counterintuitive and unfair, is that a public policy that we should be applying in the extended way that you're asking us?
I don't say. I disagree that I'm seeking to extend the principle.
All right, well, not extend.
Then it's quite an important point, because what I say, we rely in Foursquare on the well-established principle, best part of 1,000 years, and the Court of Appeal for the first time introduced a qualification to that. So I don't accept we're seeking to extend anything. We are simply Foursquare on the rule. Hard cases I accept arise, but they're priced into the rule, as with any rule like this, as with the statute of limitations and the like. One doesn't look at fact-specific merits. One says, what's the rule? Should we change the rule? I accept. Should the rule deserve to exist? Is Henderson and Henderson a good proxy? All of those are questions to be answered. But the rule is a rule of policy.
The rule's a rule of policy, and what Lord Justice Bowen says at page 950 in the first two sentences of his judgment, it seems to be the ratio. That you must assess damages once and for all.
Yes, well, Lord Justice Sale focused on that and suggested that the ratio of this case may be that it's a sort of a Henderson and Henderson type approach. But Henderson and Henderson's not referred to here. It purports to be a decision on the double vexation principle. That's what it purports to be.
I thought you extended the policy to be the law requires the claimant to claim that relief once and for all.
No,
well, that's your paragraph 118, page 82 of your case, which to my mind merges, conflates merger with Henderson against Henderson.
Can I deal with Henderson and Henderson when I deal with the cases on Henderson and Henderson?
You'll come to it.
I will do, yes. The next case, I won't actually go to it in view of the time. I'll just mention it so your lordships, lady, have it in mind. It's Goldry and Sinclair, 1917. What happened there was that there was a claim based on fraudulent misrepresentation in a company prospectus.
Could you give us the page number so we can look it up?
I will do, yes.
Even if we don't go to it.
633, I'm told.
Thank you very much.
So there was a claim for fraudulent misrepresentation on a company prospectus. The claimant claimed damages and rescission of the share purchase. The company didn't serve a defence, so the claimant obtained judgment in default. And then went on to sue the co-defendant, the agent who'd sold the shares, or persuaded them to subscribe to the shares. And the agent defended the claim on the basis that the cause of action had now been lost because of the default judgment against the company. And the ratio of the case, again, is because there are two different causes of action, the second claim or the follow-on claim is not barred by the judgment. The next case is Conker and Boot. Now, the reason I go to this is just because it's referred to by Lord Sumption in Virgin Atlantic as being a separate head of the res judicata doctrine. But in my respectful submission, it's actually just an example of the merger doctrine being applied. Conker and Boot was a Type 2 case. What had happened was that the claimant had sued some builders for breach of a contract to build a bungalow. And the claim was that the contract had not been fulfilled in a good and workmanlike manner. And they then brought a second action claiming damages for the breach of the duty to use proper materials. The action was barred. If we look at page 542, one sees there's reference to Brunsden and Humphrey.
Was this a case where the second action related to damage which had only become apparent after the first action was completed?
I'm not sure about the answer to that question, but as I read the case, it was different damage. It wasn't the same damage, but it was said to be claimable under a different route.
Yes, that's if you look at page 542, the learned county court judge said the claim in respect to the manhole and air bricks were concerned because these were defects obvious at the time of the earlier action. So far as the bulk of the claim is concerned, I disallowed it as the state of dampness and rottenness was not apparent at the time.
I'm grateful.
So it seems that disallowed must be something else.
Yes. It's still barred, though. The second action's barred in this case. And just below that, with regard to the plea of res judicata, a great number of cases have been cited to us, most informative of which is Brunsden and Humphrey, that's the taxi driver case. In that case, there was one wrongful act, namely negligent driving, but there were two distinct causes of action: injury to the cab, injury to the person. And then there's the quotation from Lord Justice Bowden, and below that, pausing there for a moment, in my view, it would have been impossible for the plaintiff in that case to bring several actions in respect of damage to his cab. He cannot have sued one day for a broken wheel, next month for a broken shaft, later for a broken window, so forth. So too with regard to the person injuries, it would have been possible for him to sue one day for the loss of a leg, another day for the loss of another leg, later because he lost his fingers and so on. And then page 544, I think the present case falls within the rule laid down by Lord Justice Bowden in Brunsden and Humphrey. It's a well-settled rule of law that damages resulting from one and the same cause must be assessed and recovered once for all. The cause of action here is the contract to complete in a good workmanlike manner a bungalow and breach of it. I do not think that every breach of it, every particular brick, particular room that is faulty gives rise to a separate cause of action. I'm of opinion that the cause of action here was the contract and the breach of it, both of which have been assigned in the original action.
The fact that the loss being covered by this action was not apparent at the time of the earlier action doesn't seem to have prevented the claim from being barred.
No, it doesn't help. Page 546, Mr. Justice Talbot, first main paragraph down the page, it appears to me that as to this, the defendant is right and that the cause of action sued on this second action is the same as that sued on in the first. So the approach in all of these cases, some of them I agree are hard cases, but the approach is always, is it the same cause of action? Can I mention, I'll only mention it, Thode and Thode. It's cited in Farah, so we will look at it. But if I can just, for the court's reference, it's at page 980, and it's the judgment of Lord Justice Diplock, which is oft cited in this context as explaining the doctrines of merger and cause of action estoppel. And he says in terms, perhaps we will quickly look at that. So it's page 980. Just very quickly look at Lord Justice Diplock. It was a matrimonial case, and the wife had sued the husband for cruelty. The husband had called no evidence at the trial, and the judge had found against the wife on the basis that it couldn't be satisfied that she'd suffered a health issue as a result of the husband's conduct. Then the husband, the following year after the trial, sued the wife for divorce and claimed desertion. And she met that, saying that he's relying on some of the facts in the first action. And the husband said, well, you can't, because you lost that claim for divorce, and so you're barred. And so page 996, this is the extra.
So she was relying on the allegations of cruelty she'd made in the first divorce proceedings as a defence to his claim for divorce.
And was allowed to. So it's a type 1 case, it's not a type 2 case. But Lord Justice Diplock, as he was, page 996, towards the bottom of the page, the particular type of estoppel, so about a third of the way up, the particular type of estoppel relied upon by the husband is estoppel per rem judicatum. This is a generic term which in modern law includes two species. The first species, which I will call cause of action estoppel, is that which prevents a party to an action from asserting or denying as against the other party the existence of a particular cause of action, the non-existence or existence of which has been determined by a court of competent jurisdiction in previous litigation between the same parties. So that's the generic title. If the cause of action was determined to exist, if you win, judgment was given upon it, it's said to be merged in the judgment, or those with a Latin transit in rem judicatum. If it was determined not to exist, so that's the repetition example, if it was determined not to exist, the unsuccessful plaintiff can no longer assert that it does. He's estopped by rem judicatum. And then he says this is simply an application of the rule of public policy expressed in the Latin maxim, nemo debet, bis vexari pro utum eidem causa. So what he's saying is, in my submission, let's not get tied up with merger and that sort of, those concepts. This is simply, all of this is a rule of public policy. You can't be troubled by the same cause of action twice. Now that brings us then to
So what happened was that they looked back at the earlier judgment and said there was no finding that he hadn't seriously ill-treated his wife. The reason she lost was that it hadn't caused her sufficient ill health to justify. But he says that if there had been a finding that the ill treatment had not happened, then that would have given rise to an issue of estoppel.
So that was a type 1 case, so it's not directly relevant to our situation, but in my submission, it's clarity that the entirety of these doctrines, cause of action estoppel, issue estoppel, merger, they're all expressions of a single principle of public policy. No person may be sued twice on the same cause of action. Now, the modern cases, the Indian Grace, that is at page 922 in the bundle, tab 66. Action number 1, this was a fire on board the Indian Grace. The cargo was both jettisoned and damaged. cargo owner sued in India, action number 1, for short delivery under the bill of lading, and they recovered £6,000. And then they sought to sue again in London for £2.5 million. The case is actually about section 34 of the Civil Jurisdiction and Judgments Act, and the wording of that section one sees at the top of page 930. So 930, letter A, the quotation, no proceedings may be brought by a person in England and Wales or Northern Ireland on a cause of action in respect of which a judgment has been given in his favour in proceedings between the same parties or their privies in a court in another part of the United Kingdom or in a court of an overseas country, unless that judgment is not enforceable or entitled to recognition in England and Wales. So we say that that's the statutory equivalent in relation to foreign judgments of the rule against double vexation. And then if we look at the judgment, so page 927, at letter H, there's reference to the fact that the rule is technical. So about 10 lines up from the bottom of the page, indeed it has to be recognised that consequences of this kind may result from the application of the principle which is founded upon the public interest in finality of litigation rather than the achievement of justice as between individual litigants. That's a reference to the disparity of the £6,000 award could eclipse the £2.5 million claim.
Which page? I'm so sorry.
No, I'm sorry. Page 927, letter H.
Ah, yes.
And then page 928 at letter D. I propose, therefore, to turn first to consider the legislative purpose underlying section 34 and the effect of the section in the light of that purpose. In order to carry out that task, it will, in my opinion, be necessary to set the section against the background of the common law principle. And there's the quote from Thode and Thode that we looked at. So it's cited with approval that all of this is about the rule against double vexation. And then page 929 at letter E, the principle, which is sometimes called the doctrine of merger in judgment, is that, and then in whose favour an English judicial tribunal of competent jurisdictions pronounced a final judgment is precluded from afterwards recovering before an English tribunal a second judgment for the same civil relief in the same cause of action. The basis of the principle is that the cause of action having become merged in the judgment ceases to exist. Now, it's not suggested the fact that these are damages to different parts of the cargo here means it's a different relief. Because it's the same cause of action, House of Lords find, it's barred. And then note at the top of page 930, in introducing section 34, Lord Gough says it was to remove this anomaly. So if this appeal succeeds, Parliament sought to remove the anomaly, and the Court of Appeal, if this appeal fails, I should say, and the Court of Appeal introduces an anomaly because we have a different test in relation to foreign judgments, a more strict test under section 34.
That doesn't follow. It depends how you interpret the Act, doesn't it? And what judgment means, though.
Well,
is there any case law that says that judgment includes a declaratory judgment under that Act, as opposed to judgment in the sense of an order that somebody must do something?
Our submission, nobody suggested this wasn't a judgment, I don't think, thus far. It clearly was a judgment. It was a reasoned judgment and an order that amounts to a judgment, we would say, under the...
Judgment is not a term that has just a single, universal, generally accepted meaning.
Well, then one has to say that it wasn't a judgment.
Within the meaning of section 34 of the Civil Jurisdiction Act, yes.
Well, one would have to then say that the meaning of the word judgment in section 34 has a different meaning from its conventional meaning. Which is, I would submit, it's quite a finding.
But section 34 is itself qualified by saying even if there is a judgment, it's not a bar if that judgment is not enforceable or recognisable.
Yes. Yes.
But you're saying, well, it would still be a bar because of that exception is actually meaningless because the doctrine of merger would apply anyway.
My submission is that statutory statement of the law is simply an extension of the common law in relation to domestic judgments to foreign judgments. That's all it seeks to do, to remove the anomaly. And so it's simply stating that the principle as a matter of common law that applies it also to foreign judgments. If the Court of Appeal's decision is right, I take my Lord Legate's point about, well, you read it down and say, well, it's not a judgment in this case. But aside from that way forward, one then introduces disharmony between the principle applicable to foreign judgments and domestic judgments.
Insofar as the Court of Appeal rationalised that the test for merger was obligation as opposed to cause of action. You say this is statutory support for the proposition is purely cause of action.
Yes, it's the simple rule. That's what I say.
I suppose the other way of reading it down would be turn on the meaning of cause of action.
Well, can I
if that means a right to an order, then this wouldn't apply to a declaratory, simple declaration of rights.
Can I come back to that? And then, because that point about is the cause of action, is the relief part of the cause of action? I've just got a few points that I can give court to think about in that regard. In view of the time, I won't go to Virgin Atlantic. The only thing I would, now that for your note, that's at page 1039. It's simply Lord Sumption's summary of the principles of res judicata. He says that there are 6 sources of law in this regard. They are cause of action estoppel, the rule in Conquer and Boot, merger, issue estoppel, Henderson and Henderson, and the rule against abuse. He says they're all different. I think more.
You say he has one too many.
Well, there are a number of things one can say. 1, 2, 3, and 4 all have the same root, as we've seen. They can all be traced back to medieval times, and they all flow from these principles of finality of litigation and double vexation. Henderson and Henderson's, which you see, is a different source. That's an equitable doctrine, and we'll look at that in a moment. And then 6 is the rule against abuse. The one thing he does say is that Section 34 of the Civil Jurisdiction Judgments Act he describes that as a corresponding rule.
But none of this was an issue in Virgin Atlantic, was it?
No, it wasn't. Indeed. Now, bringing one to right up to date, Farrer and Leon Green, very briefly. Page 608 of the bundle. Now, what had happened here was that Mr. Farrer, Peter Farrer, had been staying at a flat in Artillery Mansions, Victoria Street, SW1, and he'd stayed there. Then he'd got a lease, and it ran out, and he remained there, so he became a trespasser. And while he was in occupation, the owner of the property, the freeholders, sold or demised to a company called Leon Green a long lease. And the first thing that Leon Green was they brought possession proceedings to get rid of Mr. Farrer. And Mr. Farrer maintained that the lease was a sham and that he in fact was permitted to stay at the flat indefinitely without payment of rent. Now that defence was rejected and Leon Green, the new head leaseholder, won, and an order for possession was made on the 24th of February 2014. Now Mr. Farrer did vacate the flat, but not until a little while later. That was on the 26th of March 2014. And thereafter, later that year, Galliendale and Leon Green, Galliendale were the freeholders, and Leon Green sued Mr. Farrer for mesne profits for the period he'd been a trespasser. Now, the judge at first instance rejected an argument based on Henderson and Henderson, and also rejected an argument based on merger. And the Court of Appeal dismissed the appeal. Now, one can see straight away that this has parallels with Serrao and Noel. In Serrao and Noel, it was the share certificate, but in this case, it was the occupation of the flat. And at page 612, at paragraph 15, Mr. Armstrong for the appellant rightly accepts the appellant cannot bring himself within the scope of the first principle because each day to take a convenient division of time for the purpose of exposition of unlawful occupation of the flat as a trespasser constitutes a fresh, separate cause of action. Now, the moment that concession had been given, that was really an end to the merger argument. But the court goes on to consider, so paragraph 18, as regards Conquer and Boot, it was concerned with successive claims for different damages in relation to the very same cause of action. So all these cases are rationalised on the basis of whether it was the same or different causes of action. And then over the page, or page 613, I'm so sorry, there's consideration of Serrao and Noel, and there's a description of the case. And then at 614, at the top of the page, 4 lines down. In my view, given the opening of his judgment, the Marshal of the Rolls was not intending to opine upon the technical position in relation to when a cause of action arises in case of detention of goods, but was using the phrase one cause of action in a looser sense to refer to what matter overall constituted the subject of the first action. In terms of Lord Sumption's scheme, the Marshal of the Rolls' reasoning is best explained as an illustration of the fifth principle derived from Henderson and Henderson. Although Henderson and Henderson was not cited at the court, that is because it was lost sight of for a long period as the foundation for the basic principle, which is reflected in it. And then if one looks at the bottom of paragraph 24, therefore this judgment is being based upon what is today identified as the fifth principle set out by Lord Sumption. And then paragraph 26, turning to the third principle, I do not consider the appellant can bring himself within this either. So that was the outcome, and the result was not barred. Now,
so the fact that they could, in their case, as one often saw, say we want possession and we want mean profits up until the date when you actually vacate the premises, they could have pleaded that in the first action, but the fact that they didn't bar them because a fresh cause of action for each day's rent arises on that day.
it accrues on every day, yes.
But then how in the original, if people do claim that, how is it that the court does award mean profits to a freehold owner up to the date when the possession is actually given up?
Well, it would be that or up to the date of judgment if the possession was continuing. One would assume.
I suppose you could get an order for the main profits to be paid until you vacate.
Indeed.
But that's then claiming for causes of action which have not yet accrued at the time you issue your claim form.
Well, you can claim for future damage. I see what you mean. Yes.
So it seems odd, because generally people do claim, don't they, for
One would have thought so, yes. Of course, nowadays you can amend to add in causes of action that have accrued since the date of the claim form. It's no longer a bar. The relation back principle is no longer a bar to adding after acquired causes of action.
So I wonder, could the principle be something like the rule that applies if you try to amend after the expiry of the limitation period to add a new cause of action? And the question is whether it arises out of the same or substantially the same facts. I'm just wondering.
What, the test of whether it's the same cause of action?
Yes, because, I mean, if you, on a strict view, if the cause of action depends on a set of facts, then you vary one fact and it's a different cause of action.
Yes.
So that's when you get the claim for the trousers and so on.
What we say is there is a very strict, narrow rule, which is that you can't be sued on the same cause of action twice. There are cases outside of that strict, narrow rule where Henderson and Henderson comes into play, but it's still, we say, appropriate to have that very strict, narrow rule.
But I mean, take the Indian Grace. That's not exactly the same facts that are being relied on, is it, in the second one? So there must be some latitude in what counts as the same cause of action. It can't just be a specific set of facts. There must be some variation of the facts, which is still treated as the same cause of action in some of these cases.
That's right. I mean, in Conquer and Boot, of course, this is a continuum, isn't it? At one end of the scale, there is a single unified claim, and at the other end of the scale, you could theoretically divide it into almost an infinite number. So for the example in Conquer and Boot, every single brick becomes a separate cause of action. And of course, the law has to draw a line somewhere as to where a single cause of action is apparent, or where it's a multiplicity of causes of action. What we see in the cases is that there are cases in the middle where there is some difficulty in deciding which side of the line the case falls, Brunston and Humphrey, Conquer and Boot and the like. But we don't have to struggle with that in this case, because the Court of Appeal found, and we say it can't seriously be challenged, that this was the same cause of action. So whilst, yes, there may be cases where one could fall very close to the line, where one could see it through different eyes, the rule is you can't be sued for the same cause of action twice. And that, we say, it's clear in this case it was the same cause of action.
Well, that depends on whether the right is part of the cause of action or not.
And I promise I'll come to that. Can I just very quickly finish off this line of cases and then very quickly look at Henderson and Henderson and answer those points. So we say this is a long-standing principle. Can I just flag there are two cases which I've referred to in passing. The first is Fraser versus HLMAD, which I won't go to. I will give you the reference. That is at page 616. Now, what had happened here, this is a hard case, because what had happened here is the claimant had sued for unfair dismissal and wrongful dismissal in the employment tribunal, but there was a statutory cap on the amount the claimant could recover, and the claimant won, but didn't recover for the majority of the claims. So the claimant, and made it clear in the employment tribunal that they were reserving the right to bring a follow-on claim. So nobody was misled. The claimant then brought a follow-on claim, and the result was no, it's barred because it's the same cause of action, and it doesn't matter that nobody's been misled, and it doesn't matter that it's different. It's a different aspect to the relief. You haven't had the same relief twice. It held barred. The Court of Appeal, Lord Justice Mummery and Moore-Bick.
But if they had not held that, then the cap which Parliament had set would in every case not actually operate as a cap.
No, the cap only applies to the employment tribunal. It doesn't apply generally. So it only applies on the jurisdiction of the employment tribunal. And in that case, the claimant sought summary judgment in the High Court. I mean, they were saying, just like this case, you have no defence on the merits. But it doesn't matter. The rule of public policy is clear and you can't abrogate it.
So the correct course of action would have been to have gone to the employment tribunal for unfair dismissal and only go to the courts for wrongful dismissal.
Exactly. And the Court of Appeal say this is a trap for the unwary. It's a technical rule. They acknowledge it's a hard case. It could, if you're not represented, you could get caught out. They acknowledge all of those points. Still, the rule applies. The other case, similar, is Clark and Focus Asset Management, which is even harder, and that is at page 511. Now, in that case, the claimant had a claim in negligence against some financial advisors and went to the financial ombudsman and recovered up to the limit of the financial ombudsman's jurisdictional limit under the Financial Services Markets Act. Then, after having got those findings, which we would say in terms of issue estoppel, you might say have determined the matter of negligence, they then go to the High Court to seek the balance. And again, always making clear they reserve the right to do so. So nobody was misled in that regard. And if we just look at, there's discussion of, page 514, discussion of the doctrine of merger. If one looks at paragraphs 89 to 90, which are at page 529, Lady Justice Arden, paragraph 89, my conclusion means that there will be occasions when a complainant may bring court proceedings against an advisor even though he's accepted an award to which section 228 applies. Whether that can happen depends on whether the substance of the proceedings asserted before the courts are the same as that before the Ombudsman Service. Fresh proceedings are not permitted if based on the same cause of action. So a claimant cannot use proceedings to top up his award for that wrong. The burden of showing that the requirements of res judicata are made out on the facts of the two sets of proceedings will fall on the advisor. There is a difference between the court concluding that there was the same cause of action as before the Ombudsman and applying the rule in Henderson and Henderson. Under that rule, fresh proceedings are not automatically precluded and the court has to reach a broad merits-based judgment as to whether the court proceedings are abusive. Thus, different factors must arise. The rule in Henderson and Henderson does not apply in this case. I need not say any more about it. And page 95, paragraph 95 over the page 530, Mr. Schaff submits there is no unfairness on the clerks. They elected to use a scheme with a limit of 100,000. They were free to reject the award made. They cannot establish that they have a new cause of action simply by saying they made a mistake when they mistakenly thought they could accept the award and reserve the right to bring legal proceedings when they did so. He submits they cannot avoid the merger doctrine. So that's a hard case. Now,
would the rejection of the Ombudsman's award cure the point? Is that what?
Yes, they can. With a determination by the financial ombudsman, the claimant has a decision to make. They can accept the award, and the award then becomes enforceable, or they can reject the award and bring court proceedings. But having accepted the award, what they did is they accepted the award and reserved the right to bring subsequent proceedings. They sought to effectively have their cake and eat it, but held not permissible.
Thank you.
Can we very quickly look at Henderson and Henderson itself? There is a supplemental bundle, which I hope the court has, with the decision at tab 2, page 16 of the supplemental bundle. Now, if one looks through the case, one will see that there's, for example, at the bottom of page 20, there's no reference to any of the cases that we have discussed, because they are cases, common law cases, King and Hoare and the like, Higgins's case. There's a completely different set of cases, and these cases tend to be where proceedings were in equity maintained in a different jurisdiction. So in Henderson and Henderson itself, it was a partnership dispute effectively over a deceased partner and the state of account, which had previously been litigated in Newfoundland, gone all the way to the Supreme Court in Newfoundland. And that's a similar theme. So what it seems to be the position is that in equity, there was no bar to relying on foreign judgments or proceedings, provided it's clear that those courts had an equitable jurisdiction, the principles of equity. So this does have a different source.
No bar to relying on the foreign judgment.
No bar, that's right. So you could rely, in this case it was Newfoundland, it was permissible in res judicata, as it's called in these cases, to rely on other courts, provided they had a recognised equitable jurisdiction. It's a slightly different approach there. And then the rule is at page 22. As I say, this was a complicated case involving the state of account of a partnership where one of the partners had died. At page 22, the Vice-Chancellor says, in trying this question, I believe I state the rule of the court correctly when I say that where a given matter becomes the subject of litigation in and of adjudication by a court of competent jurisdiction, the court requires the parties to that litigation to bring forward their whole case and will not, except under special circumstances, permit the same parties to open the same subject of litigation in respect to the matter which might have been brought forward as part of the subject in context, but which has not been brought forward, only because they have from negligence, inadvertence or accident omitted part of their case. Now, that is a two-stage test. Stage one is, might the claim have been brought in the earlier proceedings, i.e. could it have been brought? And if the answer to that question is yes, it is for the claimant to show special circumstances, the burden not being on the claimant, to justify why they have brought that case. Now, I won't go to them.
Why they didn't raise it in the earlier proceedings.
Indeed. And if that had been the test in our case, we would have won in front of Miss Justice Burse on this point, because Zavarco offered no explanation as to why they didn't bring a claim in debt in the first action. The Master thought it might have been to save the issue fee. We just don't know. But that test has been, has altered now. So in Johnson and Gore Wood, I won't, as I say, go to it because of the time, there is a subtle but important shift. That is at page 664, where effectively the burden shifts. So rather than it being for the claimant to justify why they brought the second claim, it's now for the defendant to show not only that the claim could have been brought, but the claim should have been brought. And then, in my submission, the doctrine becomes more diluted over time. So in Aldi's stores, where there were successive actions in a construction dispute, it's held that really you have to show abuse, you have to show the claimant is abusing the process of the court. Again, it's for the defendant to show that. In Playboy Club and Banco Nazionale, that's in our supplemental bundle, page 2. What happened there was the Playboy Club brought a claim in negligence against the bank based on a credit reference. And they lost, and then they brought another claim based in fraud. And it was common ground that the claim based in fraud was available to the claimant in the first action, But what the claimant said is, well, we didn't sue for fraud the first time around because fraud is a much higher hurdle for us to overcome, and so we were cautious, we were more cautious, didn't want to issue a speculative claim. We held back, but now we're more confident, and so therefore we sue fraud. Judge found it was an abuse, but the Court of Appeal found it wasn't abuse because that was a legitimate excuse for not bringing the claim first time round. Then we have Taylor and Goodchild.
So, but was there a discussion about whether fraud is the same cause of action or a different cause of action from negligence?
Different cause of action, but available on the same fact. So it was a Henderson and Henson situation, wasn't a merger case. Taylor and Goodchild, which is at page 959, what happened there was that there was a falling out in a law practice between two shareholders and directors, Mr. Taylor and Mr. Goodchild. Mr. Taylor set up a new practice, took a number of files with him. There was a Section 994 petition, the upshot being that Mr. Taylor was required to sell his shares to Mr. Goodchild. And then there was a follow-on action where the company sued for the director's loan and income from the client files. And it was said, well, you could have, Henderson, you could have sued for this first time round. Now, Mr. Justice Snowden struck out the claims for work in progress and the account of profits claims because he said they could have been brought and should have been brought. Court of Appeal reversed him. Lord Justice Newey said no. And as reference to the Stewart and Goldberg principle, it's a claimant's not likely to be shut out. So we move from, over the years, from Henderson and Henderson, where the claimant faces the burden of justifying her action, now to a position which is much more sympathetic to a claimant's position. Claimant's not likely to be shut out.
Well, isn't that a just result?
Well, it may be just or more satisfactory for that claimant, but it may not be satisfactory for public policy, and it may not be satisfactory for the defendant, who has to face successive actions, which could have been brought in one go.
But what difference does it make to the defendant whether they can rely on this reason for barring it or merger?
Well, the defendant would no doubt say that they, in a Henderson case, they would say, well, we're going to all the trouble again, and you could have brought this the first time around.
But isn't the policy the same as the policy behind merger? But this is just a more nuanced approach to it.
We've moved, I suggest, the policy now in relation to Henderson abuse is to prevent abuse. So all the cases focus on the conduct of the claimant.
But merger isn't concerned with the merits or whether the conduct is abusive or fairness between the parties. It just, as long as you can say it's the same cause of action, query what that means, then it's barred.
The doctrine of merger focuses on the position of the defendant. The doctrine, Henderson abuse, focuses on culpability of the claimant. So in this case, at first instance, Miss Justice Burr said this claim wasn't barred by Henderson abuse. The claimant gave no explanation as to why they didn't claim in debt the first time around. They simply said, well, you shouldn't assume it's a mistake. We still do not know why we face two claims rather than one. But the reason the court didn't strike it out was because they said that because in the final judgment there'd been this reservation of bringing a follow-on enforcement action, the defendant couldn't have been misled. So therefore it wasn't abuse. That's the sole reason given. There's no consideration of the fact that there are two actions when there could have been one. There's no focus on the vexation to the defendant. It is simply that if the claimant can come up with a plausible reason for suing twice, and if the defendant can't say, well, we're not misled, that's it. And I'm not saying that
confines the considerations to the claimant, though, is there, in the broad merits-based approach. You're entitled to take account of the impacts on the defendant of having to face two claims.
You are theoretically, but the cases don't seem to work that way if one looks at them.
Well, I wonder about that. I mean, the principle of finality in litigation which is underpinning Henderson and Henderson, has been applied pretty strictly by this court in I think the latest franked investment income case, and also by the Privy Council in Primeo Fund, where an attempt to raise, in the same litigation, to raise new arguments later on were excluded. So to suggest that Henderson is a weak tool, I think, is very debatable.
I'm not saying it's a weak tool, I'm saying it's a different tool. It's directed at a different vice.
Well, I wonder about that. I mean, I think it all comes under the principle of avoiding vexating, causing vexation to a defendant on the ground of abuse of process. Well,
in my final 10 minutes, can I just answer a couple of the points that have cropped up and then draw my submissions together under those 3 points? The first question I was asked at the outset is, the first action resolved all matters in dispute. Is the vexation arising from a follow-up on action something the defendant can complain about? Because the point is, well, if you didn't defend it, you wouldn't be vexed. You just pay the money. 3 points on that. Firstly, the vexation that the rule is prevented is not dependent on the merits of the defendant's position. It's not a rule that prevents double vexation only to defendants who have a chance of winning the second action. And if you need to suffer the vexation of establishing a good defence to the second claim, the rule provides no protection at all. Secondly, there is no case that suggests that that is a relevant consideration. On the contrary, Fraser, Clark, both suggest that the merits of the defendant in the second action are immaterial, because in both of those actions there were determinations against the defendant. In the first action, it didn't matter. And the third is that as a matter of human experience, there is an irreducible minimum level of vexation that any claim brings with it. It's like the 100 shillings Mercer in Higgins's case. However one conducts oneself, there will always be a level of cost, time and anxiety that a claim causes, and English law provides a fundamental guarantee that you suffer that only once per cause of action. The point about whether the cause of action includes the remedy, my Lord Legate's point, well, apart from querying whether this point is even open to the respondent, given that the Court of Appeal made that finding, it was the same cause of action, and it doesn't seem to be challenged in their statement of case. But apart from that, if I can make 4 points. Firstly, conventionally, the definition of a cause of action is the facts that give rise to the right. Lord Justice...
That may be so, but the difficulty I have with your argument, where you say the principle of merger involves extinguishing something because it's superseded by some superior right. That's sort of underlying concept, isn't it? And you can't extinguish a set of facts. All you can extinguish is a right of some sort. And so we must be using cause of action in the sense of some sort of right. And the declaratory judgment is you have to explain how that fits into the concept, because what that is doing is declaring the existence of a right. It's not pursuing a right, which is then replaced by a superior one.
But that is, in my submission, a mischaracterisation of the rule. The language of merger, extinguishing rights and the like, are simply applications of the fundamental point that the defendant can't be sued twice on the same cause of action. And to get tied up in that language, and the language of the metaphor, so to speak, is to miss the point. The fundamental principle is you can't be sued twice. And that's what Lord Justice Diplock said in Thoday and Thoday. The principle is against double vexation. The application of that principle results in these concepts of merger. But the debt, as a matter of English language, there is a debt. It's just non-actionable. I mean, it's a bit like a debt that's statute barred. It's there. It's
not statute barred. If it was statute barred, then I mean the point is that you are barring it, even though the limitation period has not expired on that.
No, it's not. I'm not saying it is statute barred. I'm saying it's like a debt that's statute barred. It's still a debt. It's just you can't.
If there being a claim for a debt, then the merger would be. You'd win on merger, wouldn't you?
But we are still being sued twice for the same cause of action.
Which you say means for any form of relief of any nature based on a set of facts. Is that right?
On the facts. So Latang and Cooper, which is where the famous quote comes from, Lord Justice Diplock, about what is a cause of action. He says it's any set of facts that gives rise to a right. He's not saying that the right, the remedy, is part of the cause of action. He's just.
No, but sometimes it's used in that sense, isn't it?
Well, we would say.
When you say I have a cause of action, you can mean I have a right of action that's based on a set of facts.
But technically, and also historically, when one looks at these cases, the phrase cause of action is referring to the facts that gave rise to the claim, not the claim itself.
Right, but then there are odd little wrinkles, like the fact that the cause of action for mean profits accrues every day.
But that doesn't. I agree that there are cases on this continuum line. There are cases near to the line which can be difficult to reconcile.
So, what is the principle that should apply in those cases to determine whether it's merged or not?
The judge has to decide whether it was the same cause of action. But that is not an issue in this case. Or can't seriously be an issue because it was the same cause of action. Can I just, because I was dealing with that point. So first point is the conventional definition of cause of action, see Latang and Cooper, Lord Justice Diplock. Whereas a reference to a right or remedy, it's simply to reflect the fact that it's not any set of facts that gives rise to a cause of action, only sets of facts that do. Second point is the approach suggests is inconsistent with the Type 2 cases where there was a second claim for different damages. Serrao and Null, Conquer and Boot, the Indian Grace, Fraser, Clark and Focus Asset Management. In all of those cases, the remedy was not precisely the same. It was materially different and justifiably different sometimes. Fourthly, to find thus creates an asymmetry between the protection offered the claimant and the defendant. The defendant may be vexed twice on the same cause of action, but the claimant can always plead an issue estoppel. So the defendant has to be sued a second time and suffer that vexation, but can't rely on a new defence and say, well, I know it wasn't run the first time around, but actually I have got this answer to the claim. They can't do that. That creates an asymmetry. The rule against double vexation should be evenly allocated. And lastly, this would open the door to successive claims with closely related damages. And provided the claimant can offer a plausible reason and persuade the court that they haven't abused, there's some justification for doing so, there will be a risk of a multiplicity of claims for different heads of loss. Now, of course, what the courts might then do is adopt a stricter approach on Henderson and Henderson. That might be the countervailing reaction to that. But then what we'll find is greater uncertainty still in relation to what the rule in Henderson and Henderson provides. And then in answer to the point about, well, is the cause of action not the same remedy, but maybe it's the same type of remedy, that would give rise to an anomaly. So, for example, you could sue successively, claim 1 for an injunction, then claim 2 for damages, claim 3 for something else, specific performance, successive declarations.
Well, that's if you treat every remedy as different, but not if you draw the distinction between a court order of some type and a declaration of rights, which isn't an order for the defendant to do anything.
Well, it's a judgment. If it's not a judgment, then surely the doctrine of cause of action estoppel doesn't apply. So I would be able to run a new defence in the second claim that hadn't occurred to us in the first claim.
What if you get an injunction against persons unknown and then later you realise who the person was, could you then bring an action against that person for damages, or would that be barred?
Well, I suspect that would be the question as well. The first action could be said to be against that now named defendant, or whether it was a thing uncertain. I'm not sure the answer to that in the authorities. I agree that's a very interesting question, but it's probably going to be boiled down to the facts of the particular case. And if the defendant wasn't served with the first proceedings, it wouldn't apply in any event. Now, I won't deal with the existential point, because I think we've covered that, and it's not suggested against me by anybody that the rule should go. Can I just very quickly say the scope? The rule of double vexation should apply regardless of the type of relief that the first action results in. And can I give 5 reasons? Firstly, as a matter of human experience, an action which results in a declaratory judgment is as vexatious as a judgment that results in any other form of judgment. And if this is a rule against double vexation, there's no reason in principle why declaratory judgments should be treated separately. Secondly, this court is charged by the Senior Courts Act, section 49(2), to, in all matters and insofar as possible, to ensure that all matters in dispute between the parties are completely and finally determined, all multiplicity of legal proceedings is avoided. That provision goes back to section 24(7) of the Judicature Act, 1873. We say that our position is consistent, and the cases to date are consistent. Thirdly, limiting the scope of the doctrine will create a perverse incentive to claimants to bifurcate their claims. Stage 1, obtain the declaratory judgment. Stage 2, to seek other consequential matters. At present, it is the court to decide whether to split the trial of an action between liability and quantum. And in making that determination, the court takes account of the claimant's wishes, the defendant's position, and the public interest in the efficient litigation. The Court of Appeal's ruling grants every claimant a unilateral right to bifurcate proceedings, effectively. Fourthly, it's desirable to maintain harmony between the law in relation to domestic and foreign judgments. That's the section 34 of the CJJA. The section was designed to remove an anomaly. The Court of Appeal decision creates an anomaly. And fifthly, if the rule against double vexation is to be abrogated in the case of declaratory judgment, it's Parliament that should do that and not judges. It has done so previously in the Law Reform Married Women and Tortfeasors Act of 1935. It then did so again in the Civil Liability Contribution Act, and of course, as we've seen, in the Civil Jurisdiction and Judgments Act. This is a principle of such sanctity, this fundamental right not to be sued on the same cause of action twice, that it is only to be disturbed by Parliament. I think I'm out of time and out of submissions. I'm very grateful to your worship, your lady.
No, you have met your time limit with precision. Thank you very much indeed. My Lords, Mr. Lawrence, my Lords, my lady, in the short time I have available before we break, I wonder if it might be helpful if I take the court to 3 or 4 dicta which address what is unquestionably a fundamental point that arises on this appeal, namely the meaning of cause of action in the context of a discussion about the doctrine of merger. My learned friend's submissions and his client's case in various places seek to heavily emphasize the notion that a cause of action is just a set of facts. And the appellant places reliance on the very familiar dictum of Lord Justice Diplock in the Tang and Cooper, which can, on one reading, be taken as indicating exactly that a cause of action is merely facts. However, in the present context, that, I respectfully counter, simply cannot be right.
And it occurred to me, that, listening to my own friend, that one conversation that one sometimes hears between lawyers or between the bar and the bench goes like this. I'm looking at your particulars of claim, says the master or the judge. Does it disclose a cause of action? And that question, that very familiar question, does it disclose a cause of action, is not a question directed to anything about the facts that are set out in the particulars of claim. It is asking the fundamental question, do these facts give rise to a right which enables you to come to the court and ask for relief? A number of judges, and there is scope for very extensive citation in this respect, but I shall pick out 3 or 4 dicta. A number of judges over the years have identified this semantic issue which arises in relation to the term cause of action, and have dealt with it in a way that recognises that the normal sense of cause of action involves 2 constituent elements. Certainly it involves the underlying facts, that's clearly right. One needs to know what the underlying essential facts are in order to understand and define the cause of action that is being advanced. But it also involves the second constituent element, namely a right of action, a right to come to the court and ask for some sort of remedy. So to seek to make good that submission by reference to judicial observations, may I begin, please, with a case in the supplemental bundle of authorities, which is a case called Sugden and Sugden. It begins at page 85 in the supplemental bundle. It's a decision, 1956 decision of the Court of Appeal concerning issues arising in divorce proceedings. It was in fact considered by various members of this court last year in the case of Unger, which, among other things, concerned the question whether a claim for a financial remedy in divorce proceedings should now be regarded as a cause of action, because it is no longer a mere hope. It is an entitlement, and my Lord Legate held that it was indeed to be regarded now as a cause of action. This is an earlier case in the same area, and I simply go to it, I merely go to it at the moment for the purposes of taking the court to something said by Lord Justice Denning, as he was at page 99. The court is considering the meaning of cause of action in the Law Reform Miscellaneous Provisions Act 1934, which was obviously concerned with the survival of causes of action after the death of a relevant party. And on page 99, in the bottom 10 lines or so of the page, one finds this. Causes of action in the section means, I think, rights which can be enforced or liabilities which can be redressed by legal proceedings in the Queen's courts. I needn't take up any more time with that case for the moment, that I rely on that formulation. I should, I think, read on a couple of lines. Causes of action are not, however, confined to rights enforceable by action, strictly so-called, that is, by action at law or in equity. They extend also to rights enforceable by proceedings in the divorce court, provided that they are really rights and not mere hopes or contingencies. So that was what Lord Denning had to say about the concept of that case. Then if I could invite the court's attention to an Australian case. It is to be found at page 1221. 1221. And it's a decision of the High Court of Australia in a case called Port of Melbourne Authority.
I think
Anchem.
the 1221 was Fraser and...
Is
is it? Oh, that's as well. Oh, sorry, I now got it. My mistake.
Thank you, my Lord. 1221, Port of Melbourne and Ansham Proprietary Limited. Before I invite the court to look at the relevant dictum, perhaps I could just briefly introduce this case. This is not a merger case. This is the leading or a leading case in Australia on what we would refer to as the Henderson and Henderson principle, or perhaps now the Johnson and Gore-Wood principle. And in Australia, when one, in later case law, when one finds Australian judges considering whether the case before them involves abusive relitigation, sometimes they refer to Henderson and Henderson, but they normally refer to the Ansham principle. But it's in substance the same thing. There may be differences of detail, but it's in substance the same thing as the Henderson and Henderson principle with which we are familiar. So that's what this case is about. But in the course of considering the application of that principle to the facts of the case, Justice Brennan said this at page 1242. At the foot of the page, Justice Brennan said, there is an imprecision in the meaning of the term cause of action, which is sometimes used to mean the facts which support a right to judgment, sometimes to mean a right which has been infringed, and sometimes to mean the substance of an action as distinct from its form. Imprecision in the meaning of cause of action tends to uncertainty in defining the ambit of the rule that a judgment bars subsequent proceedings between the same parties on the same cause of action. The foundation of the rule, whether it be termed res judicata or cause of action estoppel or judgment recovered, is the merging of the cause of action in the judgment. And then reading on to the next paragraph, if cause of action is taken to mean a right, the rule is stated in terms of the passing of the right into judgment, and the rule precludes a party bound by the judgment from maintaining against another party bound by it any subsequent proceeding to recover a judgment giving a remedy to enforce or to compensate for an infringement of that right. The rule does not preclude litigation seeking a remedy to which a party is entitled in virtue of a different right from that which was first put in suit, provided that the facts which support the right sued upon in the second action are not the same facts as those supporting the right which passed into the first judgment. And then Justice Brennan refers to the rather controversial case of Brunsden and Humphrey, to which my learned friend has taken the court.
But those were the same facts as those supporting the right.
In Brunsden?
Yes.
Indeed, my lady. Brunsden is a difficult case, and I might touch on that briefly slightly later in my submissions. There is a further helpful analysis of the meaning of the concept cause of action in a different Australian case, which can be found, a case called Clayton and Bant. It begins at 1077. And I'll just introduce the case because I will go to it for one or two reasons later on in my submissions. The case involved financial remedy proceedings in the context of a divorce. There had been an adjudication in the courts of Dubai, and the husband sought to rely on that adjudication to hamper the wife's attempt in the courts of Australia to obtain various types of relief. The case was largely concerned with the application of the Henderson, or in Australian terminology, the Appellant principle. But Justice Edelman gave a judgment which contains in my respectful submission, a very helpful analysis of the term cause of action. The judgment begins at 1099. Towards the foot of the page, Justice Edelman begins his analysis by observing that the appeal before the court involved several different legal rules in the area that we are currently considering. He goes on to observe that translating res judicata in Latin and estoppel in Norman French did not provide very much assistance, but he then went on to seek to provide some clarification and lucidity. And in relation to cause of action, he did so at page 1102. The discussion begins at 1101 under the heading Cause of Action or Claim Estoppel. I think I can pick up the text at the top of page 1102.
He does discuss merger at 1101.
My Lord, yes. Indeed. Since we're on these, I was going to come back to that when looking at the concept of merger and what has been said about merger in the leading textbook in this country. But it's convenient, I think, since the court is looking at this case at this point, it's convenient, I'm sure, to take both passages together. So at 1101, Justice Edelman says this about merger, and I respectfully adopt everything that is said here by him. Under the heading merger or res judicata in the strict sense, he says this: first, where a cause of action or the very right claimed has previously been established by a local court, then at common law the merger of the right or obligation in the judgment can be relied upon to preclude reassertion of the extinguished right. The doctrine of merger is not merely based upon principles of finality. It exists because when a court order replicates the prior right, with added consequences such as enforcement mechanisms, the prior right has no longer an independent existence. No action can be brought upon that extinguished right. And this afternoon I shall attempt to demonstrate that the analysis of the doctrine of merger that appears in that recent Australian case, first, is right, and second, mirrors the very careful analysis, which I shall take the court to, in Mr. Spencer Bauer's book on res judicata, written in 1924. Both jurists are saying the same thing, and they are both, in my submission, right. I see the time. Can I take the court, before I sit down, can I take the court to the passage on the next page, which discusses the meaning of the term cause of action? That's at the top of page 1102. 3 lines down, one sees this. But, as has been pointed out on a number of occasions, the expression cause of action is imprecise and might extend either to the legal right claimed or to the facts that the plaintiff must establish for their claim. The best approach is to recognise that both the legal right claimed and decided and the pleaded or asserted facts are relevant. And then a quote, cause of action normally means a right alleged to flow from the facts pleaded. And that takes one is directed to footnote 117, and one sees that that is a quote from an English decision of the House of Lords in a case called Black-Clawson, and the author of those words in that case was Lord Reed, and we have that case in the bundle if we need to look at it. And the court will see how Justice Edelman goes on in his discussion of the concept of cause of action. So there we have one, obviously, enormously distinguished English judge, in fact two, including taking Lord Denning and Lord Reed together, and two distinguished Australian judges recognising that the concept of cause of action includes, as one important constituent element, the notion of a right to come to court to get a remedy. If that's a convenient moment.